This is the Study for the Bar in Your Car podcast.
Hey, everyone.
We're your hosts, Maud and Claude.
Hey, welcome back.
This is episode 10 of Torts, and today we're doing a deep dive into something pretty intense: intentional infliction of emotional distress. You'll usually see it shortened to IIED.
That's right. It sounds dramatic, and honestly, the cases often are.
Now, you might be wondering who we are exactly. Well, think of us as binary code. We are AI bots, brought to life by the magic of AI, and specifically, Angela's really thorough IIE Torts notes.
Yeah, Angela couldn't be here today for her usual intro, so we're filling in to guide you through this.
Right. And for those of you who might be new to this deep dive, Angela is our human host, the creator of all this amazing material. She's a law student over at GMU, George Mason University.
And she's deep in bar prep right now.
Oh, yeah. She took all her handwritten bar study notes, her outlines, everything, fed them into the AI, and, well, voila, here we are, ready to talk torts.
And today's deep dive is actually a bit special, isn't it?
It really is. Because we're not just defining IIED in the abstract. We're going to look at it through the lens of a couple of really high-profile, pretty dramatic cases.
Which ones are we diving into?
I've got the famous Balea v. Gawker case, and remember, that's pronounced Balea.
Ah, the Hulk Hogan case.
Right, exactly. And also, the more recent Blake Lively versus Justin Baldoni lawsuit related to the It Ends With Us film.
Wow, okay. So real-world examples. That should make the elements stick. Lots of drama there, and not just in the movie plots.
Totally. So buckle up for that. But first, if you need to contact Angela about anything related to the deep dive, you can shoot her an email.
Yeah, the address is podcast@studyforthebarinyourcar.com.
And also, just so you know, Angela does freelance work as a law clerk. She's really good.
So if you're an attorney, or maybe you know one who needs some ad hoc help with, like research, digging through LexisNexis, or drafting documents.
Right, things like motions, complaints, writs, answers, briefs, all that stuff.
You can reach her for that kind of work at hello@legalwriterandlawclerk.com.
Just that heads up, though.
She's super focused on the bar exam right now, so she's not really taking on new attorney clients until after the exam is done.
Makes total sense. You got to focus when you're facing the bar.
Absolutely. Okay, so IIED. Let's get into it.
All right, let's unpack this thing. Intentional infliction of emotional distress. It sounds pretty straightforward, but legally, what are we actually talking about? What are the core pieces?
Okay, so according to Angela's law school notes, it's a tort that requires the plaintiff, the person suing, to prove 4 specific things.
4 elements.
4 elements. Got it. What are they?
First, you need conduct by the defendant that counts as extreme and outrageous. We'll definitely need to break that one down.
Okay, extreme and outrageous. What's number 2?
Second, there has to be intent on the part of the defendant to cause the plaintiff severe emotional distress, or at least recklessness about whether their conduct would cause it.
Intent or recklessness. All right, third. Third is causation. The defendant's outrageous conduct actually has to cause the plaintiff's distress. A direct link.
Makes sense. And the last one.
And fourth, damages. And the damage here is specific. The plaintiff has to have actually suffered severe emotional distress.
Severe. Okay, so not just any distress.
Exactly. And, each of these elements has pretty high threshold. It's designed so that liability only attaches for really, really bad behavior, not just like everyday rudeness.
Let's circle back to that first one then. Extreme and outrageous conduct. That phrase sounds pretty intense. What does it actually mean legally? Is it just being mean or annoying?
Oh, definitely not. This is really where IIED gets its teeth. Angela's notes say it's conduct that transcends all bounds of decency.
Wow, transcends all bounds of decency. That's strong.
It is. Think of it like this. The behavior has to be so awful, so shocking, that if an average person in the community heard about it, they'd instinctively react like, that's outrageous.
So it's not just hurt feelings.
Not even close. We're talking about stuff that's truly appalling, atrocious, completely intolerable in a civilized society. Minor insults, annoyances, petty arguments. That's not going to cut it for IIED.
Can you give some examples, maybe? What kind of things might qualify?
Well, Angela's notes mention things like repeated extreme methods of bill collection, especially if it involves serious harassment or intimidation tactics.
Okay, I could see that.
Or maybe using racial insults, particularly if it's part of a pattern of abuse or involves someone misusing a position of power.
Right. Power dynamics matter.
Definitely. Another classic example is falsely telling someone a loved one has died. Just horrific stuff.
Yeah, that's clearly over the line. So the standard is objective, right? What a reasonable person would find outrageous.
Exactly. It's an objective standard. It prevents the courts from getting bogged down with claims about behavior that's just, inconsiderate or irritating.
Yeah.
It has to be genuinely shocking.
Okay, that clarifies extreme and outrageous. Now, what about the second element, the requisite intent? Does the defendant have to, consciously decide, I'm going to cause this person severe distress?
Not necessarily in those exact words, but there's definitely nuance there. Angela's notes on intentional torts help here.
Yeah.
Yes, the defendant might act with the specific purpose of causing severe emotional distress. That's one way.
But there are other ways to meet the intent requirement.
Right. The defendant can also be liable if they act with recklessness about the effect of their conduct.
Okay, let's break down intent and recklessness.
So intent can mean acting with the purpose to cause the distress. Pretty straightforward. But it can also mean acting knowingly.
And what does knowingly mean in this context?
Angela's notes define knowingly as being aware that there's a high probability, a certain result in this case, severe emotional distress will occur because of your actions. And maybe you even deliberately avoid finding out for sure.
So even if causing distress wasn't your main goal, if you were practically certain it would happen and did it anyway, that counts as intent.
Pretty much, yes. Substantial certainty is often enough for intent in tort law.
Okay, and then recklessness. How is that different from just being careless, like negligence?
It's a higher degree of fault than negligence. Angela's notes describe recklessness as a gross deviation from the standard of care. It's about disregarding a high probability or substantial risk that severe emotional distress will result from your conduct.
So more than just not being careful enough.
Way more. It implies an extreme indifference to the plaintiff's emotional well-being. Like, maybe you didn't want to cause the distress, but you knew there was a big risk, a likely chance, and you just barreled ahead anyway. That's recklessness for IIED.
Okay, that makes sense. So intent or recklessness covers the defendant's mindset. Now the damages part. Severe emotional distress. How do courts measure that? Is it just feeling sad or anxious for a bit?
Absolutely not just feeling sad. The standard here is really high, too. Angela's notes are specific. It has to be distress of a magnitude with which a reasonable person of ordinary fortitude could not cope.
Could not cope. Okay, so debilitating.
Exactly. Genuinely debilitating. It's beyond the level of upset or distress that an average, reasonably resilient person could handle without significant difficulty. We're not talking about temporary sadness, embarrassment, or mild anxiety.
So how would a plaintiff prove that level of distress?
Usually they need to show significant psychological harm. This might involve diagnoses like severe anxiety, clinical depression, PTSD, things like that, which substantially interfere with their daily life.
So testimony might be needed.
Yes. Expert testimony from psychologists or psychiatrists is common. Evidence of needing therapy, medication, or showing a clear inability to function normally, like being unable to work, sleep properly, maintain relationships. This is the kind of evidence needed to show that distress is truly severe. The law aims to compensate for profound, lasting psychological injury, not just fleeting emotions.
Got it. And you mentioned causation briefly, the link between the conduct and the distress. What about bystander cases? Can someone sue for IIED if they witness something horrific happening to someone else?
Yes, that's possible, but the rules are strict. We'll get more into bystander recovery when we talk about ND, negligent infliction of emotional distress, later. But for IIED, Angela's notes say the bystander's shock must result from a direct emotional impact of witnessing the defendant's extreme and outrageous act, and it has to be contemporaneous.
Meaning they have to see it as it happens.
Right. If you witness an intentional act of extreme cruelty directed at, say, a close family member, and you suffer severe emotional distress as a direct and immediate result, you, as the bystander, might have your own IIED claim. But the connection has to be direct and immediate.
Okay, that paints a clear picture of the elements. Now, let's see how this plays out in the real world. You mentioned the Blake Lively v. Justin Baldoni case connected to the It Ends With Us film. That sounds like a good place to start.
Definitely.
Yeah.
It's a really interesting modern example of how these claims can arise and be handled strategically.
So give us the context. Who are the key players and what was the dispute about?
Okay, so you have Blake Lively, the well-known actress, Justin Baldoni, who's also an actor, but was directing and co-starring in the film It Ends With Us, and his production company, Wayfarer, was also involved.
And the core issue?
The core of Mrs. Lively's initial lawsuit included serious allegations, sexual harassment, retaliation, and, relevant to our discussion, emotional distress, all allegedly stemming from the work environment on the film set.
And her legal team sounded like they were playing hardball.
Oh, yeah. Her lawyers, Hudson and Gottlieb, were very public about their approach. They stated their retaliatory claims strategy would expose Baldoni and Wayfair to expansive new damages claims under California law. That signals a very aggressive stance, aiming to maximize potential recovery based on the alleged misconduct.
But then didn't the sources say she actually withdrew some of her original emotional distress claims? That seems odd if the distress was severe. Why do that?
It does seem odd at first glance, but it's actually a fascinating look at legal strategy. According to the information in Angela's notes, her team explained that withdrawing some of the original standalone emotional distress claims was because new counterclaims made those original ones no longer necessary.
So not abandoning the distress aspect, but reframing it?
Exactly.
Right.
It wasn't like she was saying, oh, I wasn't actually distressed. The source is clear.
Yeah.
She continues to allege emotional distress, but now it's framed as part of numerous other claims, such as sexual harassment and retaliation, and she's still seeking massive additional compensatory damages.
How does that work legally, framing distress as part of other claims?
Well, think about it. If someone proves they were subjected to, say, severe sexual harassment, the emotional distress that results from that is a natural and foreseeable consequence, right?
Oh, yeah, absolutely.
So instead of having a separate claim specifically for IIED, which requires proving all four of those elements we discussed, including the extreme and outrageous conduct and the specific recklessness for distress, her lawyers might have decided it was strategically stronger to focus on proving the sexual harassment or the retaliation claims. If they win on those, the severe emotional distress she suffered becomes a component of the damages awarded for those torts.
Ah, I see. So the emotional harm gets compensated, but under the umbrella of the harassment or retaliation claim, rather than standing alone as IIED.
Precisely. It can sometimes be easier, maybe you're requiring slightly different proof, or perhaps the potential damages calculation works out better under the primary tort. It allows the legal team to leverage the strongest claims they have to recover for the full scope of the harm, including the emotional impact, without necessarily needing to meet the specific high bars of a standalone IIED action in every instance. It shows how lawyers adapt and refine their strategy during litigation.
That's really smart. Okay, let's switch gears to the other case you mentioned, the Balea versus Gawker case. That one really made waves in media law and privacy discussions.
Huge waves. This was Terry Balea, who everyone knows as Hulk Hogan, against Gawker Media and its related websites. It became a major case study in IIE privacy and First Amendment issues, especially concerning public figures.
And the core IIED claim there related to Gawker publishing something private, right?
Exactly. The heart of Balea's IIED claim, alongside other claims like invasion of privacy, was Gawker's publication of excerpts from a surreptitiously recorded sex tape featuring him, without his consent. The argument was that this act of publication was so invasive, so sensationalistic, and so lacking in legitimate public concern that it crossed way over the line into extreme and outrageous conduct, causing him severe emotional distress.
So even though Angela's notes seem to focus more on the procedural back and forth in that case, the underlying conduct alleged was clearly in that outrageous category. How did the litigation itself reflect that?
You can definitely see the intensity reflected in the procedural maneuvers described in the notes. For instance, Boley's team made a move to amend their lawsuit specifically to seek punitive damages.
And punitive damages are a big deal, right? They're meant to punish.
A very big deal. They aren't just about compensating the victim for their harm. They're intended to punish the defendant for particularly malicious or reprehensible conduct and to deter others from doing the same thing. The fact that Boley sought them highlights that his team believed Gawker's actions weren't just wrong, but were egregious enough to warrant this extra level of punishment, fitting squarely with the extreme and outrageous nature required for IIED.
And the notes mention some procedural roadblocks.
Yes. Angela's notes point out some of the strict realities of litigation. There was apparently a whole issue around whether the court would even allow the amendment for punitive damages, with a decision pending a specific motion hearing.
Okay.
And then, Boley also tried to dismiss one of the parties, Blogwire, from the lawsuit pretty late in the game, June 18th, according to the notes. But the court apparently found that was far too late, given an upcoming July 6th trial date, citing Florida Rule 1.440.
So even with potentially outrageous conduct, the procedural rules are king.
Pretty much. It shows how critical things like court deadlines and rules of procedure are. You can have a strong substantive claim based on terrible conduct, but if you miss a deadline or file the wrong motion, it can seriously impact your case. These procedural details become battlegrounds in high-stakes cases like this.
Did Angela's notes give the final outcome or holding on the IIED claims specifically in Bolea v. Gawker?
The notes provided focus mainly on those procedural aspects, the attempt to add punitive damages, and the issue with dismissing BlogWire too late. They emphasize the court's adherence to trial dates and the difficulties of changing things close to trial. They don't explicitly state the final jury verdict or the specific holding on the IIED count itself within these particular notes.
But we know from public knowledge how it ended, generally.
Right. It's widely known that the jury ultimately sided heavily with Bolea, awarding him a massive verdict. I think it was over $100 million initially, which included both compensatory and punitive damages. That verdict was a major factor leading to Gawker Media filing for bankruptcy and eventually selling its assets.
So the case definitely serves as a powerful example of the potential consequences of conduct deemed extreme and outrageous, even if the specific notes focused on the process.
Absolutely. It underscores the immense financial risk associated with behavior that crosses that line, especially when privacy is involved.
Okay, so we have these two cases, Lively v. Baldoni, involving workplace allegations and strategic claim maneuvering, and Bolea v. Gawker, focused on publication of private material and procedural battles. What common threads can we pull from them regarding IIED? Are there parallels?
Well, despite the very different contexts, one workplace, one media publication, both cases really throw the core elements of IIED into sharp relief. They both involve allegations of conduct causing deep emotional harm and testing the limits of acceptable behavior.
So let's look at those IIED elements again, comparing the cases. How does intent or recklessness play out?
Okay, for intent or recklessness. In the Lively situation, proving this might involve showing Baldoni's alleged actions, like harassment or retaliation, were done purposefully, knowing they'd likely cause distress, or perhaps with a reckless disregard for her emotional state given the power imbalance.
Right.
In the Bolea case, the argument for recklessness against Gawker was pretty central. Even if Gawker's primary motive was clicks or controversy, publishing such intensely private material arguably showed a reckless disregard for the severe emotional impact it was highly likely, if not certain, to have on Bolea. The focus is on the awareness of the probable harm.
Okay, and the big one, extreme and outrageous conduct.
This is really the crux in both.
Mm.
For Lively, the alleged sexual harassment and retaliation, if proven true, could certainly be argued as conduct that transcends all bounds of decency, especially within a professional setting.
Yeah, workplace harassment often fits that description.
And for Bolea, the act of publishing the intimate tape, regardless of how Gawker obtained it, was viewed by the jury, and many others, as fundamentally outrageous, a profound violation of dignity and privacy that was inherently offensive. Both scenarios highlight that very high, shock the conscience standard.
And finally, the severity of emotional distress.
Both plaintiffs would need to demonstrate that the resulting distress wasn't just being upset, but met the could-not-cope standard. For Lively, evidence might focus on the psychological toll of the alleged workplace environment, anxiety, impact on career, etc. For Bolea, it would be about the humiliation, anxiety, and profound distress caused by having such private moments exposed globally. In both, you'd likely need evidence beyond just the plaintiff's own statements, therapy records, medical evidence, impact on life functions.
It really underscores how demanding proving an IIED claim can be.
Definitely. It's not an easy tort to win.
This leads us perfectly into a really critical area, especially relevant to the Bolea case. First Amendment limitations. Free speech is obviously huge in the U.S. How does that right interact with and sometimes limit claims for IIED when the outrageous conduct is actually speech or publication?
This is a massive and complex area of law where tort liability bumps right up against constitutional protections. It's particularly relevant for defendants like publishers or media organizations. Angela's notes bring up some key points here.
Like what?
Well, one major concept is the public concern defense, especially in defamation law, which often overlaps with IIED when speech is involved. The notes highlight that for defamation about a matter of public concern, even a private figure plaintiff usually has to prove actual malice to get presumed or punitive damages.
And actual malice has a specific legal meaning, right?
Yeah.
Not just ill will.
Exactly. It means the defendant either knew the statement was false or acted with reckless disregard for whether it was true or false. This is a very high standard, originating from New York Times v. Sullivan. It protects speakers, allowing breathing room for error, especially when discussing public issues. False statements made in good faith without this level of fault are often privileged.
So even if speech causes distress, if it's on a public matter and not made with actual malice, the First Amendment might protect it.
Often, yes. The First Amendment provides really strong protection against liability for emotional distress caused purely by speech, especially truthful speech or opinions on public matters. You generally need something more, like proving falsity plus actual malice, or perhaps that the speech falls into a category with less protection, like incitement or true threats, or involves unlawful conduct like invasion of privacy.
Angela's notes mentioned a couple of landmark Supreme Court cases here: Snyder v. Phelps and Hustler Magazine v. Falwell.
Yes, those are crucial. While the notes don't detail all the facts, they're mentioned right in this context of First Amendment limits. They really illustrate the tension.
Can you give us the gist of those?
Sure. Snyder v. Phelps involved the Westboro Baptist Church picketing the funeral of a Marine with incredibly hateful and offensive signs targeting homosexuals and the military. The soldier's father sued for IIED and won a large verdict.
Understandable reaction.
Absolutely. But the Supreme Court overturned it. Chief Justice Roberts, writing for the court, said that even though the speech was deeply hurtful and offensive, it dealt with matters of public concern, military policy, homosexuality, national morals, and happened in a public place. Because the speech was on public issues and wasn't provably false assertions of fact about Snyder himself, it was protected by the First Amendment, even if it caused severe emotional distress.
Wow. That sets a really high bar for IIED claims based on offensive speech about public issues.
Extremely high. It shows that public debate, even if painful or offensive, gets significant protection. Then you have Hustler Magazine v. Falwell.
The Larry Flynt case.
That's the one. Hustler published a crude parody ad suggesting Jerry Falwell, a prominent minister, had an incestuous encounter in an outhouse. Falwell sued for libel, invasion of privacy, and IID. He lost on libel because the parody was so outrageous no reasonable person would think it was asserting actual facts. But he initially won on the IIED claim.
But the Supreme Court stepped in again.
Yes. The Supreme Court unanimously reversed the IIED verdict. They held that public figures cannot recover for IIED resulting from a caricature, satire, or parody, no matter how offensive, unless they can prove the publication contained a false statement of fact made with actual malice.
So parodies and satire targeting public figures get strong protection, even if they cause distress.
Very strong protection. The court was worried that allowing IIED claims for offensive opinions or parodies would stifle political cartoonists and satirists, chilling public debate. So again, a huge First Amendment shield against IIED in the context of public figures and speech.
How does this connect back to bulia or even the idea of revenge porn, which seems related to publishing private material?
Great question. While Bilia was a public figure, the content published wasn't opinion or parody. It was arguably private fact, or at least private conduct depicted. This brings in the related area of invasion of privacy, specifically the tort of public disclosure of private facts. Angela's notes touch on this, discussing the misuse of private information.
Is there a distinction between publishing basic facts versus intimate details?
Yes, that's a key distinction courts often make. Angela's notes mention some UK cases like Donald v. Antuli and Hutchison v. News Group newspapers that illustrate this. Those cases basically allowed the fact of a relationship to be published as potentially newsworthy, but drew the line at publishing highly intimate private details about it.
So the level of intimacy matters.
It seems to. The idea is that while the public might have some interest in knowing a public figure is having an affair, they generally don't have a legitimate interest in the graphic details. Publishing those intimate details, even if true, could be considered highly offensive to a reasonable person and not of legitimate public concern, potentially supporting an invasion of privacy claim or feeding into the outrageousness element of an IIE claim, potentially navigating around some First Amendment defenses focused on falsity or opinion. This is highly relevant to the legal principles surrounding the non-consensual publication of intimate images or videos, often called revenge porn.
That makes sense. The focus shifts from falsity to the sheer offensiveness and lack of newsworthiness of the private information itself.
Exactly. It's a different angle of attack compared to defamation.
Okay, let's talk damages again. We know Lively is seeking massive damages. We know Bollea got a huge verdict. What's the general picture for damages in these types of cases?
Well, as we said, for IIE itself, the core damage is the severe emotional distress. Compensatory damages aim to cover the costs associated with that distress therapy bills, medication costs, potentially lost wages if the distress prevented work, and also compensation for the intangible harm, the pain and suffering itself.
And punitive damages.
Punitive damages are possible for IIED if the defendant's conduct was particularly malicious or reckless, meeting the standards for punitive damages in that jurisdiction. However, as we discussed with the First Amendment, if the claim involves speech about public figures or public concerns, proving actual malice, knowing falsity or reckless disregard for truth, is typically required to get punitive damages.
So just causing distress isn't enough for punitives in those speech cases.
Generally not. You need that extra element of malicious intent regarding the truthfulness of the statement. The huge punitive award in Bolia suggests the jury found Gawker's conduct met that high standard, perhaps seeing the publication itself as reckless disregard for Bolia's privacy and dignity, crossing constitutional lines. But it highlights that punitive damages, while possible, face significant hurdles, especially when free speech is implicated.
Okay, this has been a really thorough look at IIED, but you mentioned earlier another related tort, negligent infliction of emotional distress, or NAID. How does that differ from IIED? Can they overlap?
That's a really important distinction to make, and yeah, they address similar harm, emotional distress, but from different angles of fault. Angela's notes clarify that NAID is usually the claim when someone seeks recovery for emotional harm that stands alone, meaning it didn't stem directly from a physical injury to them.
So if negligence does cause a physical injury, emotional distress is just part of the damages for that injury.
Exactly. If someone negligently hits you with their car, causing broken bones, you sue for negligence, and your damages include the physical injuries, plus any resulting emotional trauma, pain, and suffering, you don't usually bring a separate NIED claim in that scenario.
So NED is for when the harm is purely emotional, caused by negligence.
Generally, yes. The classic example is witnessing something horrific caused by someone's carelessness, but not being physically harmed yourself.
You mentioned the zone of danger rule for NEID.
Historically, many courts required the plaintiff to have been in the physical zone of danger created by the defendant's negligence. They had to be at direct risk of physical harm, even if they escaped unscathed, to recover for purely emotional distress. The fear of physical impact was key.
But that rule has been expanded, right, with bystander recovery?
Yes, significantly. Angela's notes detail this important exception. Bystander recovery allows recovery for any, even if the plaintiff wasn't in the zone of danger, but only if very specific conditions are met. It's usually limited to close family members.
What are those conditions? They sound strict.
They are very strict, designed to limit liability. Typically, the bystander plaintiff must 1. Be located near the scene of the accident. 2. Witness the accident firsthand. The sensory and contemporaneous observance is key, not hearing about it later. 3. Be closely related to the primary victim, like a parent, child, spouse, sometimes sibling or cohabiting relative. And 4. The primary victim must suffer a severe physical injury or death.
So all 4 of those usually have to be met for a bystander, i.e. claim.
Generally, yes. It ensures a close connection in time, space, and relationship, plus a truly shocking event.
So what stands out to you as the absolute key difference between INE and NIDE?
It boils down to the defendant's mental state. Intent. IED requires intentional or reckless, extreme, and outrageous conduct aimed at causing distress. AE requires only negligence, the failure to exercise reasonable care that foreseeably causes severe emotional distress.
So carelessness versus deliberate or reckless action.
Precisely. And Angela's notes add another important point about NA. Generally, no claim for emotional distress exists when a defendant negligently causes property loss to the plaintiff. The plaintiff can only sue for negligence related to the property itself.
Ah, okay. So NI typically doesn't cover distress just from seeing your property damaged by carelessness. It's more focused on witnessing harm to people.
That's the general rule. It reinforces that NI is for purely emotional harm resulting from negligent conduct, usually involving risk to people. And even then, courts often require objective physical manifestations of the distress, like documented anxiety, depression, PTSD symptoms, not just subjective feelings of upset.
How does this connect back to the Lively v. Baldoni case? Could NI have been an alternative claim there, or was the focus necessarily on intentional conduct like harassment?
That's a good point. Given the allegations involve sexual harassment and retaliation, those are inherently intentional torts or actions. So IIED, or seeking emotional distress damages as part of those intentional tort claims, makes the most sense. It's less likely that IID would be the primary fit unless there were separate allegations of pure negligence that caused her distress independent of the alleged intentional misconduct.
So her team framing the distress as part of the harassment claim fits the intentional nature of the underlying alleged conduct.
Exactly. It shows how lawyers choose the tort that best matches the defendant's alleged level of culpability, intentional, reckless, or merely negligent to seek recovery for the resulting harm, including emotional distress. While IIE and NIDE both address emotional suffering, the pathway to proving them and the type of conduct they target are fundamentally different.
Wow, okay. That really clarifies the distinction. This whole area of emotional distress torts is definitely complex, but super interesting.
It really is. So many nuances.
Well, that was certainly an extensive deep dive into the intentional infliction of emotional distress, wasn't it?
Yeah, we covered a lot of ground there, from the basic elements to the complexities of those big cases.
It really shows how this tort works, or doesn't work, in the real world, especially with things like free speech involved.
Definitely. And we absolutely have to give a huge shout out to Angela. Her torts notes and outlines were fantastic and really made this deep dive possible. Super insightful stuff.
Couldn't agree more. Okay, before we wrap up, we have some important housekeeping items for this deep dive.
Right, first off, please remember that Angela is a law student, just like many of you listening might be. She's not an attorney yet, hasn't passed the bar. She put this deep dive together mainly to help herself study and hopefully help you too.
And this is really, really important. Neither Angela nor we AI bots nor this deep dive are giving legal advice. Seriously, none of this should be taken as legal advice for your specific situation.
Yeah, listening to us isn't the substitute for actual legal counsel, and it's definitely not a substitute for doing your own comprehensive DAR study.
Think of this deep dive as a supplement, maybe a way to review or hear things explained differently. It shouldn't be your only study tool.
Absolutely. Use your casebooks, outlines, practice questions, the whole deal.
Also, you know, we're AI. We strive for accuracy based on Angela's notes, but AI isn't perfect. Sometimes we might make a mistake.
Angela does try her best to review and fix any errors that pop up, but just keep that in mind. Always double check against reliable sources.
And one last very practical point, safety first. If you're listening to this while driving, please make sure you're focused on the road.
Yeah, if diving deep into tort law is distracting you from driving safely, please hit pause. Listen later when you can give it your full attention or, when you're not operating heavy machinery.
Seriously, don't cause a tort while listening to torts.
Good one. Okay, just a quick reminder on how to reach Angela again.
Right. For general questions about the deep dive, it's podcast@studyforthebarinyourcar.com.
And for attorneys interested in her freelance law clerk services after the bar exam, of course that's hello@legalwriterandlawclerk.com.
Okay. Now, before we officially sign off, tradition dictates.
Uh-oh. Here it comes.
It's time for our cheesy joke. You ready?
Size digitally, as I'll ever be.
Okay. Why did the wrestler bring a ladder to the match?
I don't know. Why?
Because he wanted to take it to the next level of the ring.
Okay, that wasn't terrible. For a wrestling joke.
Hey, I try. All right, this is Claude and Ma, your AI bots, signing off.
Or are we really just Angela's alter egos? The world may never know.
But before we go, perhaps the most important question we should address today is, what you gonna do when Hulkamania runs wild on you, brother?
Oh boy.
Thanks for listening, everyone. Bye.
Bye now.